Welcome to today's show. I'm visiting here today with Robert Wood. I'm going to call him Rob.
Thank you.
It's good to have you here. So,
Thank you, Alan.
Rob, for the listeners, you've established a prominent legal career, but I'd like you to take me with your timeline of life of how you ended up where you are today.
Gosh, well, first of all, thanks for having me. I'm not sure it's a very interesting story. I've been a tax lawyer now for 41 years, I guess. Sort of shocking to me to think it's been that long. I'm from Des Moines, Iowa. So I was my mother grew up on a farm, and I spent the first 10 years of my life in Des Moines. My parents then moved to California, and I finished high school, etc., in California. I guess for me, an eye-opening experience was a year abroad. I got placed at an English university, Sheffield University, where they make steel. And that was really the first traveling that I did. I traveled extensively that year and since. So that was an important year for me. I was an English major in college, and so and I still like to read and to write. And I didn't really know what to do after college. And law school, this was in the 1970s. Law school seemed like a good idea. And I really only knew, Alan, you probably remember this show, but most people don't these days, Perry Mason. I think I knew, there were no lawyers in my family. I knew about Perry Mason from TV. So I went to law school. And that was in the south side of Chicago, University of Chicago. I didn't like law school too much. I didn't understand a lot of things. And about the only thing I found fascinating was income tax, the income tax class I had, which was something that wasn't required, but just about everybody took it. And so I took, in those 3 years, all of the tax classes that were offered. And started out in 1979 as a tax lawyer. And I think that was mostly, I did like it. And that was probably due to the teacher, who's long dead now, but a man named Wally Blum. And he made it fascinating, made it fun. And I've really enjoyed being a tax lawyer ever since. And the story since then has been a succession of different law firms. But I've done an awful lot of things in 41 years as a tax lawyer, and still doing it today.
And I'll add to that as a footnote, that's how you and I came to know each other, that over the years you did a lot of speaking at tax conferences, teaching of tax classes, and so we go back. So
Indeed.
Rob, in fact, I remember one of the first books that you did, Taxation of Settlements, a hardbound copy. I kept that for years. And I said, I don't want to read this. I just want to call Rob if I need the answers. But if we look at today, so your current practice, you've been featured in Forbes and a lot of pieces of media as an expert. How do people know you? How do people identify you? What are your core competencies there?
Yeah, well, one of the things I like, and this is, I suppose, kind of a love-hate relationship, I guess, with the tax law. As all of us know, which is painful, it's always changing. And of course, it's essential to just about everything we do. So whether you're sort of regardless of what you're doing, everybody has to file a tax return. You have to know a little bit. You have to talk to somebody who knows a little more. And frighteningly, tax returns all have to be signed under penalties of perjury. So, the stakes are big, and obviously there are dollars involved in all of that. So, I found that every sort of new problem was a puzzle. It was sort of applying the facts to the law, digging into the law. In some ways, it's easier today because, as we all know, everything's online. And in the old days, as I'm sure you remember, as I do, everything was books, and you had a pile of books you were carrying around. But in some ways, it's harder today, precisely because the speed of things, speed that clients need responses. But you mentioned taxation of damage awards. So many things are, for me anyway, were never planned out. They just sort of happen. I'd like to say it's planned, but most things aren't in my case. And I started getting problems associated with lawsuit settlements. And once I did 1, and then 2, and then 3, and then 5, and then 100, I started writing about it. You mentioned the damage awards book, so this thick thing that nobody wants to read. So it's, here is the current, the last edition, which was 1,000 pages or so. And this is a sign of the times that I don't necessarily like. So the new edition, which was, I think, like for me, and kind of like birthing a child to get out. The new edition is all electronic, so it's a little flash drive. So I continue to write about that area, and that is, that's the core area that I think people associate my name with. And I enjoy it because litigation has infinite variety. So there are employment lawsuits and intellectual property lawsuits and slip and fall, and you name it. In this country anyway, sort of everyone sues everyone else for something. And everything has, if there's going to be money changing hands, there's always a tax angle. So that's a fun thing to advise people about, and I still do a large amount of it.
Recently, I don't think it was, maybe a few years now, you were featured in Forbes magazine about the IRS legal issues on taxations, and about a year ago, I think in February last year. A person today is awarded a lawsuit, and a lot of times these personal injuries are taken on contingent fees.
Yep.
And so they get a great settlement coming through. The attorney takes a good chunk of it, and then they find out that they have to pay some tax. Some people don't understand this, but can you give us a high level of at what time the legal fees are deductible versus non-deductible? When is the award taxable versus non-taxable? And that's kind of a big question, but just a real high level.
Sure. No, it is a big question, and it's a pivotal one. And it is, consumers, and I guess we're all guilty of this. We're all consumers of lots of things. But I think consumers understandably think, gosh, they went to a lawyer, and the lawyer is guiding them through a process of getting them money out of some kind of a legal claim. And the lawyer is competent, and the lawyer must know about taxes. And I think it is a danger area for plaintiffs' lawyers, because some of them, very well-meaning, will give some tax advice, and it may or may not be right. I've unfortunately been an expert witness in a lot of cases over tax issues, where my role is to explain the tax issues or give an opinion about whether something's taxable or not, or how something was handled. But most litigators, most tax lawyers can't advise someone how to file a lawsuit. I wouldn't be able to. And most litigators are not competent on tax. So everything, most things, I should say, almost everything are taxable. Anytime you get money, you can pretty much assume the IRS and the state, wherever you are going to view it as taxable. The big exception to that would be personal physical injury recoveries. And using the term physical means that if something is just an emotional distress recovery, and emotional distress can be very severe, the IRS says that's taxable. And there was a lot of litigation for decades over these kinds of issues, and the law changed in a fundamental way in 1996 in the tax code, inserting the word physical. So it's got to be physical. There's been endless debate since 1996 about what's physical, and that's still mostly up in the air. So I'd say you're right that lawsuit settlements, somebody gets it and they pay a lawyer. If it's 40% contingency, they recover, let's make it a big number, they recover $1 million, and the lawyer gets $400,000 and the client gets $600. So what just happened? Just about every client will say, well, I got $600,000. I didn't get $1 million, because the client almost invariably doesn't get the full $1 million. The lawyer wants to get paid, receives the $1 million, and then sends the client $600. But in that example, the U.S. Supreme Court has said the client just got $1 million. And so to your point, Alan, which is a good one, so does the client, what about that $400? If the client is treated for tax purposes as receiving it, can the client deduct it? And the answer to that was, for decades, for generations really, the answer to that was always, yeah, of course. There are different kinds of deductions, but yeah, there's a deduction. And the law changed in a fundamental way, controversially, in 2018. This is the so-called Trump tax bill, or the kind of lousy name. They always give tax laws lousy names. It was called the Tax Cuts and Jobs Act, passed around Christmas 2017. So that cut back on a lot of deductions, and that's still true. So there are lots of kinds of lawsuits where you really have to, and this is another thing that I do a lot of, figure out a way to deduct it. There usually is a way if you're creative, but the ones that are really clear, just to go back to your question, where someone doesn't need to worry, if it's all tax-free money, it's all because they got run over in a crosswalk or something. It's physical injury money, and it's all compensatory, no punitive damages, which are always taxed. Then they don't have to worry about the legal fees. None of it's income anyway. It doesn't matter if you say, did the client get 600 or $1 million in my example. But most other contexts, you need to think about the deduction. The big one that you always get, just to make sure people aren't worried about this, is if it's an employment case. And there's some whistleblower cases that are thrown in there as well. So it's an above the line deduction. So that means, in my example, the former employee, let's say it's a wrongful termination case, gets the $1 million settlement. The lawyer takes $400. The client is almost invariably going to get a 1099, let's say, W-2 or 1099, reporting $1 million, but they definitely get to deduct the $400. They just have to know how to do it. And so for me, and a lot of these things, where the rubber meets the road is making sure the client understands what their position is and how to do it, and making sure that their tax preparer, their accountant, or them if they're using TurboTax or something like that, make sure that they actually do it right, because it's a little tricky. I wish it were not, but it is, and a lot of people mess it up. And then a year or two later, even though the law on that point really isn't controversial, they end up in an audit circumstance, and they're trying to defend a position that should have been easy in the first place.
So at a high level, if I can draw your $1 million example, 40% attorney fees, net of $600,000. If the full $1 million is subject to tax and attorney fees are not deductible, then 50% rate, they're walking out with roughly about $300,000 of the 30% of the settlement there.
In an extreme case, as I say, I mean, not to say this is subverting the rules or something, but but one of the things about the tax law that I know you know is there are sort of infinite shades of gray. So there are certainly things that we as tax professionals, certainly things that people cannot do, arguments that you can't make. But there are vast areas of things that are simply not clear, or whether it's sort of arguable you can do something, and it kind of depends on the circumstances. So yeah, what you say is true, though. The way, if you read the rules literally and you apply them literally and you're not creative, I mean, there have been some cases where someone actually, because the legal fees are so high, some cases that are, on appeal and go up and down the appellate courts and this kind of thing. So many sets of lawyers where people have paid so much in legal fees, not been able to deduct their legal fees, and they actually lose money because of winning a lawsuit. And of course that makes no sense. But it does put a premium on sort of being aware beforehand, being aware ideally before the client signs a settlement agreement. A lot of these things can be shaped in the document, and that's not improper. In fact, it's smart. It's a shame not to do it. And knowing in advance, which again you can do in the settlement agreement generally, exactly what kind of tax forms you get. So almost everyone, the lawsuits settled in 2020, let's say, and then in 2021, end of January, that's when all these little forms arrive, the 1099 forms. And a lot of people open the mail and they're shocked. Well, wait a minute, I got 600,000. How come it's saying I got $1 million? And the worst thing to do is just ignore it, because then a year later, after they file their tax return, they have problems. So, but yeah, I mean, you're right. It make the dollars can be dramatic, and someone can. It's not an easy thing to explain to someone. I mean, because they want to think, how can this be? And it's a tough thing to answer.
Rob, there was people that learn about this. Oftentimes, these attorneys negotiating settlements will quickly say, "I don't know anything about tax law," which is a code for you better go get some advice on whether or not this is taxable. Making sure you have competent advice. And I'll tell you, people that come to me on this, I send them to you because I don't want to deal with it. You'll hear about the things of, well, when I complain to the attorney says, well, why don't I split this into two pieces and I'll just give you a net number, and I don't know what that's about, but let's say that they were heading down a path of only reporting to the IRS the 1099. But I mean, the thing is, I guess there are things that people can do about, but oftentimes in insurance settlements, those guys that lose, they're not happy. They want the IRS to know, right?
Yeah, and you raise a good point. I mean, I don't think it happens a lot, but I have seen it, and I've occasionally been on most of the time, I guess, because the party who's receiving money is typically more worried about taxes than the party paying it. In a business context, defendants are always, almost always, writing off, deducting the cost. It's a business expense. They didn't want to get sued, but it happened and they had to pay somebody. And they're writing off lawyers' fees. There are some exceptions to that in the sexual harassment area, another thing that happened in 2018. But you're absolutely right that sometimes a defendant behind closed doors with lawyers will be saying, we had to pay this person millions of dollars. They were bad, and we shouldn't have had to pay. They're angry. How can we make sure that this person pays as much tax as possible? I mean, that happens. And so, the other side of that equation is the plaintiff and the plaintiff's lawyer should be worried about that and thinking, okay, before I sign this, sort of, how can I get screwed in this deal? But you're right. Being a plaintiff's lawyer, I guess being any kind of lawyer is difficult. It's hard to know how much tax advice to give. Do you give any? Do you just say, look, I'm not competent. You got to get some tax advice, or at least I'm telling you, you should. You don't have to, but it's a difficult circumstance, and it kind of happens every day because there are so many lawsuits. Oh, and one other thing I should say clearly, I find this surprises a lot of people, that it doesn't matter if your case has been litigated up and down the courts for a long time, or it's just a sort of a private mediation that nobody knows about. It's all quiet. Sort of you send a letter saying, I'm about to sue you, and then you meet quietly. How much evidence there is about the claims varies in those, and you're typically much more hamstrung by the documents in a case that's been litigated heavily, for obvious reasons. But it's the same set of rules. What's the case all about? What did you get? What do the documents say? And what kind of tax positioning can you do later?
So, do you find oftentimes that clients coming to you independent of their personal injury attorney, to say, hey, Rob, can you help look at these documents before I sign them? Is that a common occurrence?
Yeah, that'd be very common. And I would say, once in a while, I look at the documents and say, it looks good. Go ahead and sign. But that's pretty rare. I'd say 99 times out of 100 or more, there's something. It's not that it's wrong, that something can be improved. And a very common one would be, it may categorize everything correctly, but it doesn't say anything about a Form W-2 or a 1099. And so you don't want to open the mail at the end of January and be surprised with that big 1099. And even though I said, look, in almost every circumstance, the 1099 is going to be for the full amount, there's a lot of, or can be a lot of jockeying. I certainly do a lot over, wait a minute, should this money be taxable? Post-traumatic stress disorder is a great example. So that's I think the first client I saw with PTSD was with people coming out of the military. But it's very common now in sort of bystander cases, or cases involving something terrible you see, or a terrible fear that you experience, some trauma that, no one hits you, but it's nevertheless very real trauma. Even in the workplace, it's very common now that people end up with, some kind of verbal abuse and pressure, and somebody else might react differently, but they react very badly in a life-changing way. And there is no tax case that says post-traumatic stress disorder is one of these physical things that would make it tax-free. But there's also no case that says the reverse. So I think and I've written a lot of tax opinions on this, I think there's a very good argument, and I believe strongly it's physical. I have no medical training, but I've read a lot about it, and I've seen a lot of clients with PTSD. And so that's one of these examples where, if you get the right things in the settlement agreement and the right tax treatment, and often I can convince a defendant that is correct. Sometimes I have to write them an opinion or something. Then you've positioned the client so that it doesn't mean they'll never have to pay any tax, but it typically means that I could write a tax opinion supporting a tax-free treatment, and then even if the IRS examines it, that I could defend it successfully. And the goal is, if you turn back the clock and hadn't done any of that, it's sometimes possible to still come out that way later, but it's a lot easier if you put sort of the building blocks in place up front.
Rob, I appreciate you being with us today. And where do you see where do you see things headed in the world of litigation? Things going through the court system. I guess is there quite a backlog with COVID of things not moving now?
Yeah, I mean, this is what this is what trial lawyers tell me. There's a lot of frustration, and there are many cases being mediated by Zoom and other things where people are not physically present. I think for all of us who are older, or maybe for everybody, it's kind of revolutionary. Maybe this is some lemonade out of the lemons that we've all had this year. Because I think there are trials being done by Zoom these days, and certainly many mediations and depositions. I've been deposed by Zoom a couple of times since March as an expert witness. So yes, there's a big backlog, as I understand it, and the dynamics of settling cases are very different now because the threat of, well, trial starts in court tomorrow. That threat is not as real for most people as it traditionally is. But so I think my own prediction, not that I know anything, frankly, I often get asked to predict what tax law is going to pass. And it's hard to do, even though I think I know a lot. Boy, I'm not good at that. There are a lot of things that I know should pass and I think aren't even controversial, and I'm sure they're going to pass. Tax treatment of legal fees is a good example. There have been proposals to change this, change the deductibility rules, and that haven't gone anywhere. But as to sort of my prediction on litigation, I believe that most of the things that I've described are gonna stay in place. It's kind of a nitty-gritty. You got to look at your case, forgetting about changing the law. Look at your case, position the client as best you can, and follow it through. It's a lot of it. It doesn't require that much creativity or smarts, I don't think. The law isn't that complex, but it's attention to detail. And so I guess if I had to, I've certainly made a lot of mistakes, but if I had to say one thing I've really learned over and over again is, with clients and with opposing counsel and with the government, is, look for every comma, watch everything if you can, and be a little bit paranoid. Be thinking about, how can this go wrong? What haven't I thought about? But I think we're going to have, on this area of the law anyway, and maybe this is true throughout tax law, kind of a lot of more of the same. Pay attention and try to think ahead and document things as best you can, because lots of things can go wrong and the stakes can be pretty big.
Been visiting here today with Rob Wood. Rob, thanks for being with us.